Lordship. Lordship is regarding bail. NDPS Act has invoked your Lordship. Lordship, the brief fact of the case is that the accused person
Is your microphone on? Is it on or off?
is on. The brief fact of the case is that your Lordship, the accused person, along with his other three friends, they were going towards West Bengal to his relative house, your Lordship, and in the midway. And the police from the Clarion, they got some information from, like, Lordship, there's a different part of the story. If you take your Lordship, para 3 of the petition, your Lordship. May I read your Lordship?
Yes.
The information one, SIJ Dakar of Clarion Police Station lodged an FIR on dated 19/6/2023 alleging inter alia that around 5:15 p.m. Receiving an information from so-and-so MPS Additional Superintendent of Police Jantia Hills that one Tata Tigor of white color bearing registration number so-and-so was signaled to stop, but the vehicle dropped in a very rush and negligent manner with a high speed, thereby about to kill the NTF staff, the police personnel of Nongsing Naka, thereby indulging the life of the police personnel present in Naka. However, it's about 5:45 p.m. The vehicle detained near the police station and two occupants of Sri Jainal Das, son of so-and-so, and Sri Pranay Masudar of Tripura, and one of the occupant, namely Gaurav Gupta, son of so-and-so, and fled away with the vehicle. The villagers and the police were able to detain him. After a small chase in the processing, the said person were beaten up by the villagers and sustained minor injury. Next, please, Your Lordship. On initial interrogation, the detained person voluntarily stated that the said vehicle is loaded with illegal contrabands. Further, the detained person, Sri Jainal Das, also stated that the owner of the vehicle and the contrabands, namely Karanjit Sarkar, son of so-and-so Tripura, and his three friends were traveling in a Hyundai 120 bearing registration number so-and-so, and all of them were aware of the contrabands, were transporting it the intention. Lordship, that Sri Jainal Das, who has informed the police that the vehicle loaded, the Tata Tigor vehicle loaded with the contrabands, is the owner Shri Karanjit Sarkar, along with his three friends, they were aware of that contrabands. Lordship, here the accused person, he don't know about the contrabands, he don't have idea. Only the thing was that he was traveling along with Karanjit Sarkar to his relative house. It was just an unfortunate decision, Your Lordship, that the accused person was decide to travel along with his friend Karanjit Sarkar, and in the midway, they just caught in the midway, and he is not aware of any of the fact. And for that decision, Your Lordship, the accused person is suffering in the jail since 1.5 years. It's been 1 year 5 months. He is in judicial custody, Your Lordship, and charge sheet has filed. So at this stage, Your Lordship, I pray at least Your Lordship call for the records and pass necessary order, Your Lordship.
Yes, my lord. I have to go through, my lord, though it seems the charge sheet is being enclosed here, my lord. If this matter can come day after tomorrow, well, 1 and 2 are connected, my lord.
When was charge sheet filed?
Charge sheet filed on Lordship 27 of 2023.
And what is the stage of the case?
I'm not ever at this moment, Your Lordship. What is kindly call for the records and
Should be brief about the facts and circumstances of the case.
I have to take instruction. I have to take instruction, Your Lordship.
If charge sheet has been filed, then charges must have been framed. Evidence may have been recorded. How many witnesses are there? How many witnesses have been? Anyway.
We'll take instruction, Your Lordship.
On pre-made by the parties, this is matter after 1 week. So by 1 week, you come with all the status report.
My lord.
You try to find out.
See. Lordship.
Deployable. 1 and 2 are connected now.
Same order.
Same order.
Daily list item number 1.
May it please Lordship.
Yes.
Lordship, I pay for further 3 weeks' time to file my rejoinder, Your Lordship. Your Lordship, I'm waiting for the respondent to file the affidavit, but all the respondents have filed, and respondent number 2 has filed it yesterday, Your Lordship. I've just received.
Oh, who had filed the affidavit in the meantime?
Respondent 1 and 3 have already filed quite ahead, Your Lordship. Respondent 2, they have recently filed. We're yet to receive copy.
There are only 3 respondents.
Yes.
Yes, Lordship.
Would have done it.
Positively by 3 weeks, Your Lordship.
Not 3 weeks, 2 weeks at the most. Miss G.C. Moro, Leonard Marbo, Leonard Counsel for the petitioner, has once again sought for some more time to file the rejoinder affidavit to the rejoinder to the counter affidavit filed by the respondents 1 and 3. Now, in the meantime, the respondent number 2 has also filed the counter affidavit, and the same is filed the counter affidavit. On premier, the same is allowed. Let the counter affidavit rejoinder to the counter affidavit filed by the respondent be filed within the next date fix. This is matter after 2 weeks.
Item number 2.
Please, Your Lordship. Lordship, in this appeal, notices have been served on 1 and 3. Respondents 1 and 3, 1 has appeared. 3, my Lord, we have filed an affidavit of service. As far as 2 is concerned, my Lord, we've tried to serve notice on multiple occasions. The records will reveal at least 4 times, if I'm not mistaken, my Lord. Each of those times, my Lord, the notice has come back, cannot be found, etc. Now, respondent number 2, my Lord, is the owner. And the appeal we have filed, essentially, my Lord, primarily we are pressing only one ground, that is on the quantum. According to us, there has been a misapplication of Supreme Court judgment, Pranay Sethi's judgment, and because of which the quantum has been inflated. That is the primary ground that we are urging, my Lord. And my Lord, as far as the owner is concerned, Lordship, I draw Lordship's kind attention to what Lordship has done in similar previous matters, where Lordship has taken the view that the appeal is but a continuation of the suit. Now, once in the suit, the matter has gone ex parte against a particular party, then for at the appeal stage, which is essentially the suit, to again issue notice, to again wait for him to appear, would be to give a second bite at the apple, a second chance, which is not necessary. If Lordship, I can.
But why have you, if that is the case,
yes,
why have you arrayed him as a respondent?
Yes, but by way of abundant caution, only for the reason.
You see, at the before the
yes, ma'am.
MSCT.
Yes.
Have you taken your defense under 170?
170 we have not, my Lord, expressly for the reason that 170, my Lord, is no longer in vogue ever since a judgment passed by the Supreme Court in 2016.
Yes, of course.
So we have not filed a petition or anything of that sort. So what Supreme Court had said in 2016 was once year.
If not specifically,
yes,
filing of taking of defense of the owner, driver, so on and so forth.
Yes.
If the owner or the driver, particularly the owner,
yes,
is not present in the proceedings,
yes, madam.
Surely you must have taken up, his defense as far as the,
during the conduct,
concerned,
yes, madam. During the conduct of the proceedings, my Lord, we took all defenses.
That must have been done by you.
Yes, my Lord. Yes, my Lord. So essentially, we've stepped into the shoes of the owner, my Lord. Now, to wait for the owner when he cannot be found at all, if I can draw Lordship's attention.
Matters proceeded ex parte against the owner
before MST, my Lord. Before the MST. If I can draw Lordship's attention to Lordship's previous order in a similar MSC appeal, para 2 of this order, my Lord. Learned counsel for the appellant has further submitted that since considerable efforts have been made to cause notice to be served upon the said respondents, but with no positive result, and considering the fact that this is an appeal which is a continuation of the proceedings of the suit, or rather the claim referred before the MSCT, therefore it is prayed that the respondents number 2, 3, 4, 5 may be proceeded ex parte in these proceedings. On consideration of the prayer made, subject to the appearance of the respondent so-and-so at any point of time, for the time being, the matter shall proceed ex parte against the said respondents. So, my lord, as I was submitting, we've made multiple attempts, my lord, at least 4, if not 5, my lord. There's been no success. If lordship can pass a similar order in this matter, if the necessity arises, if lordship is of the view at some point in the future during the course of hearing that their presence may be required, then we'll redouble our efforts. But for the moment, my lord, I would humbly submit that Honorable Court has waited long enough for the respondent.
And claimant is
Mr. H. Hazarika has been appearing, my lord.
okay. He has entered appearance.
He has, on a previous occasion, he had entered appearance.
Not today.
Today he is not here.
We should hear him. Whether he, he would
Whether
object to your submission or
whether, lordship, whether owner is present or not present would,
it makes no difference.
makes no difference.
But since he is,
True.
he is, he should be rather in attendance.
Very well. Very well.
We'll pass over for the time being.
Very well. Or maybe
Try to find out if Mr. Hazarika is around.
I'll look for him. Or maybe it can come at the end of the week, not Friday, or Thursday, Friday. Or next week, whatever's convenient.
We'll do one thing.
Yes, ma'am.
We'll pass over.
Very well.
If in the meantime he comes, at least some order will be passed.
Yes, ma'am.
Otherwise, waiting for another date, then it just gets the matter prolonged.
My lord, I'll look for him. Obliged.
Item number 3.
My lord, we are entering appearance, my lord, on behalf of the sole respondent. My lord, I just wanted to point out 2 things, my lord. My lord, kindly come to page 18, the prayer portion. My lord has the prayer portion. My lord, may I just read? In the premises aforesaid, it is most humbly prayed that your honor may be pleased to admit this appeal, call for the recourse, issue notice upon the respondent to show cause as to why the impugned order dated 4 December 2024, passed by the learned district judge, District Council Court, Shillong, in Miss so-and-so should not be quashed and set aside. Kindly note 4th December 2024, my lord. My lord, now, my lord, kindly come back.
Here, I know. Here it is noted as 28th.
Then I have been supplied with a wrong. My lord.
Your Honor, I may be allowed to rectify the errors, my lord. Actually, there is some typographical mistake, my lord. I apologize for my part.
Where? In his copy or my copy?
In his copy.
Then let him serve a
No,
copy.
you know, it's only corrected here.
Because even paragraph 1 also, my lord, it's not only prayer. Even paragraph number 1, my lord.
Yes. Everywhere, I think, like you said, maybe some typographical error has crept in.
My lord.
Here it is 2811.
28. 2011, and the impugned copy, the annexure, my lord, 4 December 2024 is given here. The annexure part. So this the annexure 25, my lord, 28 November 2024. That is all right. That is okay.
Yes.
But what I meant to say is that where after paragraph 1, where they said the copy of the impugned order dated is 4 December again in my copy, my lord.
My lord, that is just a minor mistakes, my lord. My lord, I may be allowed to rectify the same in the copy of my learned senior counsel. Otherwise, my lord, everything is in order.
That can be done, Mr.
My lord, My lord, again,
My lord,
paragraph
it's the
5.
same. It's the same. Just the date ratification, my lord, is the same of the impugn order, my lord. That can be rectified. That is not an issue, my lord.
Again, paragraph 5 also.
Yes, my lord. I can do that, my lord.
Do one thing, Muslim.
My lord.
You give back your copy to her. Let her
My
make
lord.
the correction and hand it over to you.
My lord.
Everything.
The rest, my lord, I have no problem with the dates, my lord.
We'll post this matter for hearing.
Hearing, my lord.
My lord,
Obliged.
just my humble submission, my lord. On the 27th of this month, my lord, the trial court will proceed with this matter, my lord. So here the preliminary issue is that the suit is barred by limitation. Since the suit is barred by law, my lord, there is no purpose that in the trial court the trial will commence, my lord. So I only pray, my lord, that my lord will only stay the proceeding, my lord. Since the Limitation Act is applicable in the state of Meghalaya and the appellate court has made the wrong observation on that, my lord, so that order should be set aside, my lord. So my only prayer is that to stay the proceeding of the trial court, my lord, because the trial will commence on the 27th, my lord, of this month. So just my humble submission, my lord.
Well, that is next week, my lord. If my friend can correct and give me a copy on Wednesday, we can have it on Wednesday 19th.
My lord, I'll do it in the course of the day, my lord.
But the hearing might take some time.
Yes, my lord.
So I'll dispose of this missed case for stay with the direction that status quo will.
Yes, my lord.
As on
My
today.
lord, because without my lord, my opportunity to object to the to the stay applications, my lord, because I don't have the copy, miscellaneous application copy, nothing with me, my lord. So,
My lord, it's the same, my lord. There is no difference, my lord. It's the
Because,
same,
You have filed
which is.
You have filed an application.
Yes, my lord.
This is
I
miss-
have already served.
This is
copy,
missed
my lord.
case.
My
Missed case number 26. Copy should have been given to the other
no,
side.
that is nothing, my lord. We have received this package, my lord, where was only the CRP was there, my lord. So, with all fairness, my lord,
Yes,
let it be taken on 19th, my lord, Wednesday,
Give him a copy.
my lord.
My lord, I've already supplied the copy, and regarding the CRP, my lord, I'll correct it within the course of the day and supply the copy to the.
Pray made by the parties. Let's just matter on 19th.
19th.
Highly obliged, my lord.
Obliged.
Item number 4.
These are the bonded warehouse bills, my lord. But there are a few very important developments in this matter, my lord. Those are very unfortunate things that has happened, my lord. My lord, lordship recollect there are 3 FIRs filed against the petitioners, my lord. One in Bagmara, Tura, and Khanapada. In Tura case, we have been granted bail earlier, my lord. So we are on bail. Bagmara lordship is granted interim bail, and Khanapada lordship also granted interim bail. So on Sunday, the petitioners, my lord, the accused persons went and appear before the Khanapada police station, my lord. They reached there morning time, my lord, along with 2 lawyers from Delhi, one from Delhi and one from Jaipur. So what police did, detained all 4 of them in Khanapada, my lord, took away the telephones of all the 4 people, and they informed. They make them detain till evening, my lord. Evening time, Tura police came, my lord, to Khanapada. The whole purpose was, everything was orchestrated, my lord. And a POXO case has been clamped on them, my lord, on the accused persons. Tura police took them away to Tura, my lord, from Khanapada police station. And that was on Sunday evening they have taken them away. And till now they have not been produced in Monday morning. Sunday night they were in Khanapada police station, my lord. Monday morning they took them away. Today is Tuesday. Till now they have not produced. When we try to get the FIR, what is the FIR, the POXO case? They are not giving the copy of the FIR also, of the POXO case. But I have the documents, my lord, that they are sent for medical report. I'll give to my friend also, my lord, on Sunday. My lord, this is something, my lord, which is very unfortunate, my lord. The lordship will see Government of Meghalaya, Office of the Officer in Charge, Khanapada Police Station, Medical Health Officer, reference Khanapada PSGDE number 6 dated 16/2/25, my lord. That was day before yesterday. With reference to the above, I am sending herewith the below noted person. He is in detained in connection with WPS, Women PS 2025 PT3 so and so dated 16/2/25 and Women PS case number 8 of 25 under section 351 so and so, read with section 18 of the POCSO Act, my lord. Now, my lord, this is what the police is doing, my lord. Khanapada police detains, informs to Tura police, my lord, I don't know for what reason. They detain him till evening because by the time police comes from Tura, my lord, they keep him overnight. And what is most surprising, my lord, that the lawyers, okay, one lawyer from Delhi and one from Jaipur, they took away their phone also. Somehow by evening they returned the phone, and the lawyers from Delhi and Jaipur, out of fear, they ran away, my lord. Because there is every threat that even they will be possibility of their arrest, my lord. So somehow they managed to run away. Next day, what happens, my lord? Next morning, the police gives the phone to the son, the prisoner number 2, and asks him to arrange 10 crore rupees, my lord. Then he said, I don't have 10 crore rupees, from where I'll arrange. And then they took him to Tura, my lord. So these are the subsequent developments, my lord, which I wanted to. Until now, they have not been produced before the magistrate, my lord.
One. Lordship, if this fact that my friend has stated, if this would have been in a formal affidavit, first thing, because when the matter was listed on Friday, I had got a status report and the case diary. I had sought for time because I just got it in the court log. So Lordship, so far that case is concerned and the status report is concerned, if I may just 5, 6, 17 and 18. Now let's address this issue first, Your Lordship, then we can come to the issue raised by my friend. As on 14/2, the status is on clause number 60, 17 and 18.
Yes.
So now 17, Your Lordship, what happened? Now we will require further, we'll have to submit a further report.
But this is, you see, this is with regard to the situation as on
14.
September and
Lordship, yes. Status report is of 14/2, Your Lordship, will kindly see.
14/2, yes.
So Lordship will recollect when the bail application was moved, Lordship had declined for any interim, saying that what exactly has culminated from whether 41 was issued, whether he complied.
Yes.
So many counterfacts was there. We said we are not in the position to let us file a status report. Status report of 14/2/2025 clearly says that, Your Lordship, after receiving notice way back in September 9, till the filing, he had never appeared. In spite of the fact he had got an interim, still he chose not to, and then they withdrew. So basically, so far the important issue that this Lordship had raised was whether 41 was issued, because if it is an issue of below 7 years, then either way police cannot arrest because they have to comply with it, because there is a consequences of Ernest Kumar. So, but right now we have a situation as in 14/2 that 41A was issued, but he chose not to comply.
This is with
regarding to
Khanapara. This is Khanapara case.
Khanapara case. We were basically into Khanapara case. The other cases are coming up on 24th.
Okay.
So that's why there are too much of overlapping of cases.
Now
my friend has made a submission today. This has to be ascertained in Lordship, because the case diaries are with us.
So in compliance with this court's order, Lordship, he had gone to the police station on Sunday.
Sunday.
Sunday
was 16.
16. So he had gone on 16th. This is a report of 14. Oh,
Lordship had granted interim till next returnable date on Friday. Till next returnable date, he should not be arrested.
Yes. So today is the returnable date.
Today is the returnable date. He should not be arrested.
So he had gone on 16.
Lordship, yes.
In the meantime, these developments
happen. So we'll have to urgently file a further status report as to what happened on 16 till this. Lordship will file it by Friday.
So as far as this case is concerned, then we will assume that he has appeared before the IO.
the development what my learned senior has mentioned, Lordship. If I can.
Have you filed that the POXO FIR also?
Lordship, this one at around 1 o'clock, this honorable court was pleased to grant interim bail to the accused person. Now, Lordship, I have given one the FIR which my learned senior was talking. This FIR we have addressed the last page of this report, Your Honor. Last page of the report. If I can draw your attention to the last page, Lordship. Last page. This is the WhatsApp call made, Lordship. He is a vital witness in this case, Lordship. It is on Friday, Lordship. At the missed calls were made 3 times. And on the 4th call.
Give us a copy also, at least.
And on the 4th call, he was threatened, Lordship.
Who was threatened? Who was threatened?
The witness. He is the witness, vital witness.
Who is the witness?
Witness is Lordship. His name is Kishore. In the mail ID is there.
Yes. Okay. Now.
He has threatened his minor daughter who is studying in Pura, Lordship. Has been because they stated over the phone, Lordship, that your daughter, since we have the interim bail from the High Court, we are moving to Meghalaya to comply with the order, and your daughter is in Pura, so we are going to kidnap her, we are going to rape her, unless and because you have testified against us, you are facing the dire consequences. Getting feared, Lordship, he immediately went to the...
My Lord, I am not able to understand. My friend, what I appear is appearing for the complainant in the Khanapada police station. That is why she intervened. How is he appearing now for the Kishore Kumar who is filing this POXO FIR, my Lord?
Yes, Kishore Kumar, he is a witness in this case, Lordship.
Yes, but why? I mean, how are you involved with this? With him?
Lordship, he is a witness. Lordship.
Yes, he is a witness. Lordship. But that would be within the confine of the investigation. It is the IO who would know his identity, who would have called him.
Lordship, because Kishore Kumar is the cousin of Gopal, so he knows that Kishore Kumar has testified against him. He is the cousin of Gopal.
Oh, it's okay. That is, those are, that's a different situation altogether. But now you have intervened before this court with this, and you are the complainant in this. You are a complainant in this Khanapara case.
Yes, Lord. I am a complainant in Khanapara.
It's so apparent, my Lord, the collision, my Lord.
That has got nothing to do with this.
Only shows the collision, my Lord.
Anyway, that would be incumbent. It would be incumbent upon the IO to look into all the angles and see if there is connivance, even with any authority for that matter. Then the court has to be apprised of the situation. It is incumbent upon the PP also to apprise the court of this situation, and necessary orders will pass.
Yes, Lordship, that's why I submitted. What happened after 7 days till now? We'll have to file a status report because there's a cross allegations against. So we right now, unless the status report come, what developed and what happened?
My Lord, my concern is that in spite of bail in 3 cases, my Lord.
See, Dr. Muzika, whatever the case may be,
my Lord,
let's try not to confuse the situation or the issues. As far as this matter is concerned,
my Lord,
this is a standalone matter. Now you've come with some submission or information, whatever, before this court, saying that your petitioner now
is in compliance with the Lordship's order. I went to
is in custody in relating to some other cases.
My Lord.
So that is a matter of procedure.
And different case. Yes.
My Lord, that we oversimplifying the thing, my Lord. Here, what happened in compliance with Lordship's order, we go before the IO, my Lord. The IO of Khanapada police detains not only the accused persons, my Lord, even the lawyers, and then informed Tura police station, my Lord. Now, what business Khanapada IO has got with a case registered in Tura woman PS case, my lord. Is this notified? Is a red corner alert issued, my lord, all over the country about this case? How does he know? He informs them, detains them till the evening, my lord. Then they come over, my lord, from Tura.
Well, Lordship,
Well, I've never heard this kind of thing happening, my lord. It is not an Interpol notice or red corner notice, my lord, that every police station will be alert that one accused person will come, you have to arrest him, my lord.
Lordship, both are disconnected facts. So, for appearance is concerned, there is no allegation that after appearing he was still arrested in the case. In spite of the fact,
to circumvent the order, this is what they've done, my lord.
Lordship, let us clarify the facts at least first, because we are having too much of overlapping facts. It is not the case of the petitioner that in spite of the fact of the court's direction, he approached and he was arrested in this case. Then court would have taken a different view altogether.
That is the
Lordship, yes, though we have to delineate the facts. The issue is this: in another case, why police informed Tura, that is a different cause of action, subject matter, and different PS case registered. That they can file independently. So that has got no bearing with. The only thing was he has to appear, and there is no allegation coming forward from my friend that in spite of the fact there was a no arrest order, he was still arrested in this particular case.
Well, that they'll not do, my lord. What my friend is submitting. Will they dare to do that, my lord? They'll dare to do that. They'll try to circumvent the order by doing this kind of things.
There's nothing to be emotional. There are two important facts overlapping. So, if
the government should advise the police, my lord, how they should behave with the court, my lord.
No.
This is going beyond. The lawyers are threatened, my lord. The lawyers have to run away.
Please file.
To save
Please
their
either
life,
file an affidavit or in the POXO case, Tura, bring this fact. Then maybe court will call for a separate report from the Tura police investigation.
That is what I'm saying.
Otherwise we are trading into.
My lord, my difficulty, my lord.
He may have a case. We are not denying it.
Please. My lord, the same thing happened because there were 3 FIRs and they were fearing that if we appear in one case, my lord, because we got interim in one, but other case we did not have interim. The moment we appear, they'll come and arrest us, my lord, because we are not having interim bail in the other case, my lord. Now this time, my lord, we had bail or interim bail in all 3 cases, my lord. That's why we advised them, please come at the earliest possible time and appear before the IO. They orchestrate a new story, my lord, now. And Khanapada police informed Tura police, my lord. And they blatantly demand 10 crore rupees from the accused persons, my lord.
Who had demanded?
Police, my lord.
If that is the case, then you have to, as Mr. Khan had said, I think
the law will take its own course, Your Lordship. It's a very impersonal machinery. Not for a moment I will be defending the police trying to, any illegal action.
Exactly. You see,
Should not also.
we have to get to the
law is very clear. I have given Lordship the copy of the judgment.
we have to get to the bottom of this.
Absolutely.
If there is, you see,
Malafide intention by the police, yes.
Any, untoward action by the police in any manner connected with this case or connected with any other case, as far as the petition is concerned,
The consequences, legal consequences have to follow.
see, necessary orders will be passed.
Absolutely.
But those, as Mr. Khan has said, those facts have to be brought in a proper.
At least in
My difficulty, they are in custody, my lord. Police is no. In fact, someone went yesterday to police station to please give the FIR. They chased them away, police, my lord. The lawyers from Tura, my lord. They said, in this case, you please don't interfere. Please don't come for this case.
What is this, Mr. Khan?
That's very, very, very unfortunate. What my friend is submitting me, that is the case.
And by difficulty, I can't even file an affidavit, my lord. Both are in custody, my lord. And moreover, they have been detained in a hotel, my lord, to avoid production before the magistrate in 24 hours, my lord.
Lordship, had it been in violation of this court's order in this case, I would have assisted the court. I would have been in the same page with my friend that these consequences will have to follow.
This is consequential to when they went to appear before the IO, my lord, in connection with this case, my lord.
No,
My lord, what I pray, my
it's
lord.
true. It may be consequential,
My lord.
but the fact remains that a separate.
I appreciate, my lord, that is altogether a separate case, my lord. But our difficulty, my lord, today, my lord, as far as this case is concerned, my friend is asking for time to file another status report. Let him file the interim bail, may be extended, my lord, till then. As far as this case is concerned. But my lord, something has to be done about this case.
You should have submitted that.
Since you have stated that you have appeared before the IO, so the court will take cognizance of that.
My lord. And that is evident even from the medical report that Khanapada PS is sending the petitioners to for medical examination, my lord. The document I placed before lordship.
Lordship, the only legal issues, I would have still assessed the court if my friend would have said, once a court grants an interim, the police has got no power and there's a bar imposed on police to send.
Dr. Mozika, if whatever if your advice accordingly, you file a petition.
It will be better, Your Lordship, then we can ask.
Any appropriate
My
petition?
lord, at least to lordship in this matter, because I'm handicapped, my lord, give a direction to police, my lord. If you go there to sign an affidavit from the accused, they'll facilitate, my lord. They're not doing that. They're not giving copy of FIR also. At least in this matter, your lordship will take that much cognizance, my lord, and give a direction to police, my lord.
So that we can do, of course.
We'll leave it to the court, yes. But as I said, Your Lordship, be another matter coming up 24. It's too much of overlapping of facts.
It's not overlapping, it's a high-handedness, my lord.
No, but Lordship can understand the constraint.
But
if such allegations are brought,
there is some connivance, collusion,
Lordship,
whatever.
law has to follow. Law has to take its course. Absolutely.
Between the concerned police and whatever parties.
Absolutely. Even let the submission that my friend made, Lordship, let him make a statement on affidavit.
Even an accused in a murder case is given his due right.
Absolutely.
It may be heinous, it may be brutal.
The rigor of procedural law has to be followed. We are praying. So the fact that my friend is submitting, let him also bring on affidavit. Otherwise, orally, Lordship, where do we stand?
I'm not even in a position to file affidavit and what they are doing.
Your case, we understand. I'm talking about my friend, the complainant.
The complainant is appearing for whom?
Let her bring certain facts on record before on affidavit. Because we have got cross-purpose of facts emerging in Lordship, at least something on oath, so that the court can pass an appropriate direction and we can ask for a status report from the concerned SP. Lordship, kindly understand my constraint.
This FIR is registered in Rajasthan, my lord, on the basis of which Tura police has come to.
Lordship, the accused has informed the Tura police also because he was feeling threatened because his minor daughter is in Tura, Lordship. Then
that's a different thing.
Daughter will not be able to study, Lordship.
That is a different thing altogether.
Place of incident, Lakshman Ghat, Rajasthan, my lord.
Important thing is that, Lordship.
So that is miss, that, like I said earlier, that is a different case altogether.
Lordship.
The police can take recourse in accordance with law.
Lordship.
Due procedure has to be followed.
Correct.
Lordship.
But if the allegation is true, that the police have demanded certain sum
10 crore rupees, my lord.
Lordship had
It's a very serious.
To release him or to do away with the case, or
In morning yesterday, my lord, they gave the phone to the son, my lord. Said you arrange 10 crore rupees to settle the matter, otherwise we're not going to release you.
Lordship, can it be being on record, Lordship, that the police has asked for?
exactly.
It has to be brought on record if such thing has come up, Lordship.
Now, are you appearing for police? I don't know. My friend, whether she is appearing for police, my lord. If Mr. Khan says that, my lord, who is she, my lord?
Really serious.
It is serious.
Making an allegation to the police, who is an investigating agency, Lordship. It is a very serious allegation, Lordship.
Everything will be borne out in due course.
Once it's on record, then we have to give an effective reply. If the court is not satisfied, there are consequences to be followed. Or maybe an inquiry will have to be conducted. Court can direct for an inquiry.
Habeas corpus inquiry. Till now, they have not been produced in court, my lord, after detention.
Heard Dr. N. Muzika, the senior counsel, who has submitted that the petitioner herein had
Who is appearing for
petitioner herein, in compliance with this court's order, had appeared before the IO at the Khanapara PS Ribhoi district on 16th. He was accompanied by 2 advocates, you know the name of those advocates?
The advocate is Mr. Vishwapal Singh.
The 2 advocates, namely Shri Vishwapal Singh from Delhi, and
Another from Jaipur.
and another advocate from Jaipur. It is
Access to all these documents, so somebody else has not.
next one. The learned senior counsel has further submitted that instead of
The lawyers would remain in bound also. Money is good.
dealing with the petitioner as far as the Khanapara PS case is concerned, the trio were detained at the police station for apparently no reason till evening of the same day, with their mobile phones being taken away from them. In course of the day, some police officers from Tura police station appeared at the Khanapara PS and took the and detained the petitioner in custody. Apparently on informing him that he is a suspect in connection with an FIR. This FIR was filed before Tura,
But the case is registered in Rajasthan, my lord.
but this is the FIR that
This is what is he produced, my
no, on
lord.
the basis of this is FIR he was detained.
On the basis of the FIR, he was
This FIR is Rajasthan, my lord.
This court will not take
But
cognizance of
woman
this.
PS case number is given, my lord, in Tura also.
Who has given?
In the paper I produced, my lord, before lordship. The forwarding to hospital, my lord.
Or this one?
My lord. It shows, my lord, woman PS case number 8 of 2025 under section 351(2)(3), 79, 61(2)(b), 35 BNS, read with section 18 Post Act. The handwritten body, lordship.
Kuntung of last paragraph. That he is informing him that he is detained in connection with women PS case number I need him. Women PS case to PS case number 222. And accordingly, he was taken to Tura, where he was further detained. Where he was further detained at a hotel. You're sure it's a hotel? Do you know the name of the hotel?
And made the daughter pay the hotel bill. Police is not paying, my lord, asking them to pay.
Detained at the hotel, at a hotel in Tura. Top. It is also the learned senior counsel has also submitted that the petitioner, on being detained at the said hotel, has not yet been produced.
Not even produced. Till now is not been
Has
produced.
not yet been produced before any magistrate, in spite of 24 hours having lapsed since then. It is also the submission is also the further submission of the learned senior counsel that the hotel bill was made to be paid by the daughter of the petitioner, and that a sum of rupees 10 crores was demanded from the son of the petitioner to settle the matter. Was demanded by a police officer.
My lord.
Was demanded by a police officer. This next one, this change of events is nothing but an attempt to implicate the petitioner by any means as far as the allegation made against him are concerned, where cases are where FIR has been filed in 3 police stations, that is at Tura, Bakmara and Khanapara. No communication has been, no communication with the petitioner was allowed to be made, and thereby at this point of time the family members of the petitioner are not able to contact him or to take any steps in this regard. It is prayed that this court may take judicial notice of the statement made here. Mr. K. Khan, Leonard PP, has submitted that the allegation made, if proved to be correct, are very serious, and would impact the conduct and integrity of the police force, including police force at large and the particular police officers and the police officers, particular police officers in question. It is therefore prayed that the petitioner may be directed to file an affidavit in this regard to allow the prosecution to respond to the same. Ms. P. Bhattacharjee, learned counsel for the respondent number. Respondent number 2 had produced copy of the FIR and related papers, copy of the said FIR, comma, under which the petitioner was arrested by the Tura police. It is the submission of the Land Council that the FIR was lodged by one of the witnesses in the case against the petitioner, and who was subsequently threatened by the petitioner, even to the extent that a threat was made to kidnap his and apprehend the witness daughter. Hence the FIR and the subsequent arrests. This court has carefully considered the submission made for this considered submission made by the parties. As far as this instant case is concerned, and as far as this is concerned, though the learned PP had submitted that an FIR and a status report filed by the IO would show that would reveal that till the 14th February 2025 the petitioner has not yet appeared before the IO. However, in the light of the submission made by the learned senior counsel for the petitioner that the said petitioner had appeared before the IO on 16/2/2025 at the Khanapara police station. Therefore, the fact that the petitioner has appeared before the police cannot be denied. However, the learned PP has also further submitted that as to the other part of the allegation made by the petitioner herein through the learned senior counsel, it would be incumbent upon the petitioner to pursue a separate course of action as far as such allegations are concerned, to allow proper inquiry or response by the investigation by the police. This court is in agreement with the submission made by the learned PP and would however, whatever has been submitted at the bar discarded or brushed aside, considering the seriousness of the allegation made. The situation has taken a serious turn inasmuch as, firstly, the liberty of the petitioner has been compromised, and secondly, serious breach of conduct and even illegal action supposedly perpetrated by police officials have been alleged, which requires thorough inquiry. Therefore, even while allowing the petitioner to even while allowing the petitioner to chart out his own course of action, this court hereby direct the state respondent to file a comprehensive report as to what exactly transpired at the Khanapara police station on the 16th February 2025. As to the submission made by the General Counsel for the respondent number 2, this court would question the bona fide of such statement, inasmuch as the respondent number 2 has no say in the conduct and course of proceedings of the investigation, and it is strange to note that a copy of an FIR not related to her was produced before this court. If not clarified in future, this court would take due note of such conduct and necessary observation or action may be taken against the respondent too, if so warranted. Be that as it may, in the light of the grave situation as has been portrayed by the petitioner herein, this court further directs hereby direct the Superintendent of Police, West Garo Hills District, to look into this matter and to file a separate report. Look into the matter of the alleged detention of the petitioner at the said hotel and the circumstances surrounding such situation, and to file a detailed report before this court on the next date fix. Anything else?
Except Lordship, the first part with the state has to file state Lordship is just a small addition SP revoy. Through the SP revoy.
So I have to go to SP boy.
Because second part is correct Lordship, the SP of South Gari. The first part is to Lordship mention only state. SP revoy.
Today is
18.
24th. This is matter on 24th for further hearing.
The Lordship extended the interim.
In the meantime, the interim relief, what interim is already in custody now.
At least in this case, my lord. Otherwise, they'll again go to Tura and arrest him.
In the meantime, the interim relief given to the prisoner is hereby extended until further orders.
Next date. Second order, same matter.
Same.
His son, my lord. Number one was father, second is son.
Son also was arrested.
My lord. In fact, the father is not even named in the affair. Only son is named.
The same order.
Only in some places, wife
Yes,
and
because in that order I've said that his son was whose son now? The son of the first petitioner or the
son of the petitioner, my lord.
First petitioner or second?
First is father, my lord, second is son. Gopal is father, my lord, and
Yes,
Rahul
but
is son.
First case is Rahul. Rahul Sharma is the son.
Rahul is son, my lord. Sorry.
So I have passed the order in this first case. Or should I pass the order in this?
This order should go in number 2, my lord.
Number two.
And in the first, slight changes because in some places, Lordship has said son. So that will
Yes.
become.
This order should be in 2.
Okay, we'll pass separate orders.
Absolutely.
Kalau separate, tahu should correct tu. Kalau dia son, naya tu son. The son, the money was demanded from him.
From son, my lord.
Katu cakap tu demanded from the son, demanded from him. Okay, I'll make the correction.
Dip.
Item number 6.
Check to go. Yes.
Please, Your Lordship. Lordship, we're being led by Mr. Paul in this matter, and I'm praying for some accommodation today.
What is this matter about?
Lordship, essentially, we, the petitioners, are an export association. We are Majai Exporters Association, and we export limestone to Bangladesh via the Sora, the Bholaganj to Companyganj road. And there's a 500-meter stretch of road which is disputed in this case, Lordship, because there's a certain toll that has been collected by the same of Sora in this matter, which we are challenging. We're challenging his authority to collect that particular toll, Lordship. That's essentially the matter.
3 weeks.
So when do we?
Lordship, 3 weeks. If
3 weeks. Because 1 month to here, no, they have.
Accommodation is being sought for on behalf of the Learned Senior Counsel, Mr. K. Paul, who is in bereavement. On pre-mid, matter is adjourned. Let's see after 3 weeks.
3 weeks. Obliged.
highly obliged, Lordship.
Second call, item number 2.
Mr. Hazarika has not come.
He cannot be found, my lord.
Mr. S. General, the counsel for the petitioner, for the applicant. You have filed an application for condonation
That has been allowed.
Allowed.
Lordship has allowed it.
for the appellant, who has submitted that in spite of several attempts made to cause notice to be issued upon the cause notice to be affected upon the respondent number 2, public owner, no response has come forth. In such a situation, the Learned Counsel would submit that this court may now proceed with the matter, with the appeal, in absence of the said respondent number 2, who in absence of the respondent number 2, comma, the matter to proceed ex parte against him. It is also the submission of the learned counsel that the presence of the owner, respondent number 2 owner, is not so much required as far as this appeal is concerned, in as much as the primary ground made out in this appeal would be with regard to the quantum of compensation awarded to the claimant, respondent number 1. It is therefore prayed that the matter may now be allowed to proceed to proceed for final consideration, for final hearing. This court has considered the submission made and is of the view that since several attempts have been made to cause notice to be issued upon the respondent number 2, and also the fact that the matter, and also the fact that as submitted by the learned counsel for the appellant, the matter has proceeded ex parte against the said respondent number 2, owner, before the learned MACT. Therefore, it would be logical to assume that the said owner is not interested to contest these proceedings. However, accordingly, this matter shall now proceed ex parte against the said respondent owner. However, as an abundant caution, it would be open to such respondent to join proceedings at any point of time before this appeal is disposed of. This is appeal for hearing after 2 weeks.
Objection.
I to respondent number 1 is absent.